apologize for doing the right thing. That is a fact. We, the people of Kenya, are beseeching this court to act again in defense of the law and the Constitution. If we are to summarize our grievances in this petition, it is that the first and the second respondents do not seem to understand the Constitution and the law, or either they do not understand it or they believe they can get away with disregarding the law. The starting point is 1st September 2017, because that is where this court gave its direction: go and conduct a fresh election in strict compliance with the Constitution and the applicable law. We're going to demonstrate that the first and the second respondents did not do this. Lords, a general overview and summary of our submissions will be as follows. On the question of universal suffrage, our Constitution requires that for a person to be elected president, he or she should enjoy the support of at least 50% of the votes cast and at least 25% in more than half of the counties. That requirement presumes that elections are held in a normative context with the participation of as many voting adults as possible. The purpose of these constitutional provisions should be obvious. If a candidate obtains 70% or 90% or even 100% of 1 million ballots, this court must ask itself if such an election conforms to the spirit and intent of the Constitution. It is therefore no wonder that the Constitution also provides that the election of the president must take place in each of the 290 constituencies. In this election, a total of 3,635 polling stations out of the total 40,883 did not record any votes. This represents 1,770,475 Kenyans. Our second submission will be on violence and intimidation. My lords, we have annexed to our documents and shown that there are various reports by reputable organizations, including the government's own Kenya National Commission on Human Rights, recording loss of life, harm to limb, people died, hundreds were injured, scores more sexually violated during the election. The threat to life and limb was clear and present before the polling day and on the polling day. Because of violence and intimidation, people were not able to vote again in 3,635 polling stations. Our third ground will be on the lack of independence of the electoral body. Honorable judges, this court cannot avoid the reality before its eyes. which is that the IBC appears to be under the thumb of the executive, currently controlled by the third respondent. Their pleadings are either similar or complementary. The affidavit of the chairperson is proof that the Commission was never independent, but was working overtime to please political players such as the National Super Alliance and the Jubilee Party. The internal incoherence of the Commission is proof of its own discordance, brought to light most dramatically by the resignation of Commissioner Rosalind Akombe. My Lords, part of the dysfunction of the IBC is right before this court, in the form of the affidavit sworn by the Vice Chair on her behalf and on behalf of 5 other commissioners, excluding the Chair. We will be asking the question, what is to be understood by this? The fourth limb of our submissions will be on illegality. My Lords, the IBC seems to have decided what law to follow and what law to ignore. It chose to rely on the Supreme Court decision in 2013, where it provided that only the president-elect in a nullified election and the successful petitioner should contest the fresh election, but it did not obey the direction that one candidate abandoning the race would automatically require a new election. On illegality again, the IBC printed ballot papers with Shakalaga Jirongo's name on the list of candidates on October 19th, and then gazetted his candidature on October 24th, 2 days to the election. It declared that no nominations would be conducted when it could have declared the candidates as having been nominated by dint of the Supreme Court's nullification of the August 8th, 2017 election. Finally, we will make submissions touching on dishonesty and duplicity by the first and the second respondents. My Lords, in our petition, we show that the IBC has been unable to tell a consistent story about the elections. The number of registered voters, for instance, is a moving target. The voter turnout in the fresh presidential election changed at least 3 times. It is our submission that voter turnout is the true north of any credible election result, and it is locked down at the close of polling. My Lords, I will address you on the grounds of violence and intimidation and lack of independence altogether. My colleagues, Mr. Wiper will address you on the question of universal suffrage. My colleague, Donald Dare, will address you on the question of illegality. Because of our limited time, my Lord, we will address you on those factors that we consider pertinent to the vitiation of an election. and which this court, if it decides or rules in favor of the petitioner, then the election cannot stand. My Lords, Article 81 of the Constitution sets the principles that the electoral system shall comply with. Article 81E provides that the electoral system shall comply with the principle of free and fair elections, which are free from violence, intimidation, improper influence, or corruption. 81E3, that free and fair elections must be conducted by an independent body. 81E Roman 5, free and fair elections must be administered in an impartial, neutral, efficient, accurate, and accountable manner. My Lords, we have, in my submissions, I will say, we need to look at the environment in which the election was conducted. And I've characterized that in two forms: the external environment, which was marred by violence and intimidation, and the internal environment, which is the environment within which the IEBC was operating, and which we say there was no independence, there was no impartiality, but there was also violence within the environment of the IEBC. My Lord, it is our submissions that the question that there was violence before the election, after the election, is admitted. It is not in contest. The fourth respondent has admitted in their responses, the third respondent, I beg your pardon. The third respondent has admitted that there was violence before the election and during the election. The first and second respondents equally admit that there was violence before and during the election. Indeed, my Lord, it is a little difficult to even talk about before the election, because this court has said an election is a process, and therefore everything that happens before the polling day is part of the election. My Lords, we will go no further than to utilize these addresses, the public addresses and statements that were made by the second respondent in our petition. Sorry, he's the first. By the second respondent after the consolidation, which is the chairperson, updating this country on where matters stood with regard to the election, and the circumstances in which they were operating. My Lords, I wish to refer to the statement of address made by the chairperson on the 18th of October 2017. It is found in the first respondent's replying affidavit. It's on the document, it's written, the first respondent's replying affidavit in petition number 4, at page 180. My Lords, this is the Chairman's address on the status of preparedness for the elections, dated 18th of October 2017. The statement comes a day after Commissioner Rosalind Akombe had resigned and sent out a press statement. My Lords, the first thing is that the chairperson publicly admits the resignation of Commissioner Akombe and then owns the reasons she gave for her resignation, and we will come to that. The expressions that she had made when she resigned. My Lord, in acknowledging Dr. Rosalind Akombe's resignation, this is what the chairperson had to say as he addressed Kenyans. She is one of our finest brains, and it is very sad to see that we could not provide an environment for such minds to find full expression without fear for their lives. That is an admission that there was threat to the life of Commissioner Dr. Akombe. Just a minute. Yeah, it's okay. My Lords, in the same statement, at page 181, the chairperson, speaking to Kenyans, says, "With gratitude to God and the Kenyan people that gave me this opportunity, that is why I have now come directly to the Kenyan people, because you deserve to know the state of the country's preparedness for the FPE, which I take to be the free presidential election." The fresh, sorry. Thank you. The fresh. Later down in the same statement, he says, "You have a right to know the state of things in our beloved country. I have chosen to communicate directly, also to ensure that you do not get speculative ideas or outright false news from the fake news mongers." This is the chairperson speaking. In the following page of the same statement, it says, "There are numerous calls for peace, but we all appreciate that peace without fairness and justice is an illusion of peace. It is the fountain, credibility is the fountain where true peace flows from. the Bible tells us in 2 Samuel 23:3, he that ruleth over men must be just, ruling in the fear of God, while the Quran reminds us in Quran 49 that verily Allah loves those who are just. The chairperson is speaking to the environment. Going further on in the same statement, at page 184, the chairperson confirms, and acknowledging the environment in which they're operating, that a leading candidate who garnered more than 6 million votes has withdrawn from the race. While it is his right, we must think beyond him and think of the 6 million Kenyans who will feel disenfranchised by this action. He acknowledges that there are Kenyans who will feel disenfranchised, and then asks a question: do we just go on as if this withdrawal means nothing? Later on, in the same statement, he says, I want to state categorically that I shall not go down in history as the national returning officer that plunged the country into a further crisis than I had found it. It is already painful to be on record as the chairman of the IBC that presided over a presidential election that was nullified by the Supreme Court. And then he makes the critical points and admission. I have made this point on numerous occasions to my colleagues at the Commission. I have made several attempts to make critical changes, but all my motions have been defeated by a majority of the commissioners. Under such conditions, it is difficult to guarantee free, fair, and credible elections. I am convinced that without critical changes in any secretariat staff, we may not have a free, fair, and credible election. I ask the staff who have been adversely mentioned to step aside and allow the project team to function without interference. The chairperson, in his address to Kenyans, is admitting, one, there is political interference within the IBC. He is admitting to Kenyans a week to the elections that he cannot guarantee free and fair elections. Further on in the same statement, he says, as a lawyer, I cannot continue to be pushed by majority commissioners to accept legal opinions that serve partisan interests and are not grounded in the Constitution or the law. In the least, this is intellectual dishonesty for which my professional training demands that I abhor. This is a public admission that there were partisan interests within the IBC by none other than the national returning officer. And then, further on, in that same statement, the chairperson says, once there is political agreement as a result of dialogue, when there is genuine commitment to let the commission work independently, when all the commissioners and staff truly commit to serving the country rather than partisan political interests, And when we work together to create a conducive environment for Kenyans to express their sovereign will, then I can truly be confident of having a credible presidential election. The chairperson is admitting publicly to Kenyans that the commission is not working independently. And of course, the question we should ask is, who is he blaming? Who is it that is not allowing the commission to work independently? He goes on to say, as the referee, I want to issue a stern warning to the players of this game on all sides that they should stop all attempts to interfere with the process. Failure to do this will result in consequences. I have made up my mind to uphold the Constitution and the will of the people of Kenya, regardless of threats, intimidation, or pressure. My Lord, the purpose of reading this address to you was that the IBC itself and the chairperson publicly admit the challenges they have, that they do not have independence, there is no impartiality, they are afflicted by partisan interests. And so that question cannot be said to be in contest when they have made public admissions. I had earlier said that this public address by the chairperson came after the resignation of Dr. Roselyn Akombe on the 17th of October 2017, and the first respondent indeed admits in his response at paragraph 48 that Dr. Akombe resigned from the commission and released a statement on 17th October 2017 in which she expressed her assessment of the commission's preparedness for the fresh presidential elections on 26th of October 2017. It's therefore important to see what Dr. Akombe had to say about the commission's preparedness for the fresh election. My Lords, the press statement by Dr. Akombe is found in the affidavit in volume 1 of the bundle of documents supporting the petition. It is annexed to the affidavit of the first petitioner. It's at page 81, marked NM 14. And this is what Dr. Akombe had to say. For many months now, I have questioned my role as a commissioner at the independence, for many months now, I have questioned my role as a commissioner at the Independent Electoral and Boundaries Commission, but have soldiered on, hoping that we could collectively find a way of addressing the crisis our country faces. Sometimes I have agonized over the decision to leave my committed IBC field staff and my country. My decision to leave some of you my decision to leave the IBC will disappoint some of you, but it is not for lack of trying. I have tried the best I could do given the circumstances. Sometimes you walk away, especially when potentially lives are at stake. The Commission has become a party to the current crisis. The Commission is under siege. This is an admission, a clear statement of the presence of violence affecting the work of the Commission.
Madam, is that statement hearsay, or is it a statement of truth coming from the person who perceived it?
Sorry, my lord, come again?
Is that hearsay, or is it a statement from the person who perceived it, the person who expressed it and witnessed it, the one that you were giving just now?
The statement is made by Dr. Akombe herself.
Is she the one speaking? Is there one statement by the person who witnessed the situation?
My lord, I'm not sure that I get the question correctly.
The point simply is that there are things which are perceived.
Yes.
And as a matter of evidence, those who perceive them can speak about their veracity. Those who have not perceived them can only relate them as evidence. This is basic law of evidence.
Yes.
I think you need to speak about that.
My lord, this is a statement, but that is written by the commissioner herself. It is signed by the commissioner herself as a person who was working at the IBC. As a commissioner, it would be said she perceived it and is therefore qualified to speak.
What medium is this coming? Because that medium determines veracity. This is basic law of evidence.
My lord, this is a written statement on the letterhead.
Can you vouch as to the validity and veracity of that statement yourself or any other person without the owner itself, the one who pronounced it, speaking to that?
My lord, the only evidence that we have is that this statement has been owned by the chairperson and the commission. It has not been denied. And so we take it as being a fact of what is being spoken and that it actually came from Dr. Akombe herself. It has not been denied. It has not been...
Okay, proceed.
But my lord, I think that my lord, the point my Lord Justice Ojwang is making, which should form our objection, is that whereas the statement by Dr. Akombe is fairly not in dispute, for that evidence to be brought to this court, who is making that averment? You can't make a statement made by a person and you are not making clear the medium through which you are admitting it or making it admissible evidence. Akombe has not sworn any affidavit before this court. So my learned friends should satisfy the test. Through what medium are you adducing that evidence? Because the veracity of the same, you can't adduce all kinds of statements made throughout the world, and you cannot channel it in a proper manner through this court.
My lords, an inference of truth an inference of truth must be drawn from the fact that the chairperson of the IBC acknowledges this statement, refers to it in his own affidavit. It is part of the documents that were presented. So where there is no denial as to its veracity, today it cannot be claimed that this statement was not been made. It is admitted by the second respondent himself, paragraph 48 of the affidavit. And indeed, the second respondent goes ahead to express his own views with regard to that statement. That in itself shows an admission of this statement by Dr. Akombe. My Lord, suffice to say, the purpose of that statement by Dr. Akombe, which is owned and admitted, or at least the contents, and which is why we started with the chairman's address of the 18th of October 2017, was to show the environment within which the IBC was operating. My Lords, at page, we wish to refer to yet another address by the chairperson of the IBC, the second respondent, to show that an environment of violence already existed before the election and during the election. The reason we do this is because, my Lord, we are seeking to lay squarely at the feet of the IBC the blame that the environment that existed before the poll day was created by them. They were aware of it and did nothing about it, and still insisted on conducting the election on the 26th of October 2017. And next to the affidavit of the petitioner, at page 97, marked NMA 18, is the address by the chairman a day after the election on 27th of October 2017. And the chairperson says, "Fellow Kenyans, yesterday some of my staff were hijacked and some were tortured. Some had their homes broken into and looted. Others were forbidden and violently prevented from reporting to their polling stations and were literally chased away. Some have had to take refuge in police stations. In some instances, even when the police got reinforcement to secure the IBC staff, it did not prevent the violence, as the surge of violence from the protesters was also escalated." This confirms that there was violence on the poll day. Fellow Kenyans, he continues, there are even returning officers and entire polling staff in some of the areas where a breach of peace was reported that have gone into hiding due to the resistance from those who do not want the people to exercise their constitutional right to vote. The question is, was the violence that happened on poll day one foreseeable? If the answer is yes, then the question would have to be, could the first and the second respondents hold an election or claim to hold an election that meets the test of a free and fair election in that environment? My Lords, from the previous addresses that we have read, it is our submission that the violence was foreseeable. It was already existent. Yet, the first and second respondents chose to go on with the election in that environment. Our Constitution, Article 81E, says an election for a free election to be conducted, it must be free from violence, intimidation, improper influence, or corruption. So if before the election there was violence, during the election there was violence, can that be said to have been a free and fair election? Otherwise, then we also must ask the question, how much violence is acceptable? 1 loss of life? 31 policemen dead? How much would we say is acceptable to decide this is not an environment within which a free and fair election can be held?
Council,
Yes, my lady.
but you want to be specific. Would you like to speak to where that violence was? Was it countrywide?
The areas to where the violence was? Yes.
Is that relevant?
My lady, I would not say, I do not think it is relevant. It is relevant, yes, that in some areas were affected. However, it is also not relevant that in some parts of this country, an election could not be held because of perceived violence in those areas, whether actual violence happening in those areas. And there are places where we know that the election, even though it took place, there are people who stayed away because of fear of violence erupting in those areas. But the reason why I do not think the question of where the violence happened is relevant is because the election is required to be conducted in all 290 constituencies of this country. We are one country. To say that we are only going to conduct an election in some parts of the country and leave out other parts because in those parts there is violence is to divide this country. It's to balkanize this country. Then are we saying, and my colleague will come to argue that, because then that question affects the right to universal suffrage. Are we then saying because we cannot hold the election in those parts that are affected, they do not count as Kenyans?
You're doing exactly what I wanted you to do, which is to address the effect of that violence, wherever it was.
The effect of the violence, my lady, wherever it was to deny a chunk, a large population of this country, the right to exercise their right to vote. And that right is exercised in the context of a national presidential election. Part of Article 81E, and our argument is that the principles in Article 81E are not separable. They must all be present for a proper election to be conducted.
I suspect this is something that Mr. Waikwa will probably address.
Yes.
But I hear you focusing on the rights of those citizens who did not vote in violent-prone areas. Will you be addressing equally the rights of those who had the right to vote where there was no violence, and how then the IEBC was to balance between the two, because all citizens are equal, everyone had the right to vote, there are those who could not, there are those who could.
Yes.
So are you going to address that the issue of balance on that issue? I suspect I know, probably, Mr. Waikwa, but I would like you to also address it as you speak.
Yes, Maluri, and I will address you on that right away, and which is why I laid the basis and said there were two environments. There's the external environment, and then there was the internal environment. The internal environment of the IEBC, we say, is what precipitated the external environment. Because the IEBC could not conduct itself in a manner that fostered a free and fair election, one of the things that then happened is that those who were aggrieved in certain parts of the country decided they will boycott the elections, chose to exercise their rights under the Constitution, whether to demonstrate or to picket, which led to violence before the election. Now, when before the election, violence has already manifested itself before the conduct of the election, and this is affecting other parts of the country, and the IEBC is aware that in some parts of this country, they will not be able to deliver an election that is free from violence. Can they then hold an election a presidential election for the entire country, meeting the requirement that it must be held in 290 constituencies? If in the part where some people or other parts of the country where people do not want to vote, and then there are those parts where people want to vote because equally they have the right, but they equally enjoy the right to universal suffrage. My lady.
Please, could you address one thing here? This Supreme Court ordered that elections were to take place within 60 days.
Yes.
So that was the law.
Yes.
That law also required just one agency in this country set up under the Constitution to conduct those elections. Could those responsibilities have been passed on to someone else?
My Lord, the responsibility is on the IEBC. But in reading the Constitution, we must read the Constitution holistically and not disjunctively. When reading the Constitution, our argument is that whoever, and this applies to the first and the second respondents, in interpreting the Constitution, they must apply all the principles of the Constitution. Article 140 applies with the same level as Article 81 of the Constitution. My Lord, the argument and what you're presenting is a false legal dichotomy that we believe the respondents will try to present to this court, that we have to have a choice between holding an election within 60 days, the timeline created by the Constitution, and holding an election that meets constitutional muster. Our submission is that both must happen. You do not have to choose between one or the other. There is no contradiction in the dictates of the Constitution. Whenever any question calls for interpretation, we know what our values under Article 10 are. It was incumbent upon the first and the second respondents to consider within the environment within that they're operating, under all the circumstances, are they able to meet all the prerequisites of the Constitution? My Lords, under Article 10 of the Constitution, we say these are the national values and the principles of governance that bind all state organs, state officers, public officers, and all persons whenever any of them applies or interprets this Constitution, enacts, applies, or interprets any law, makes or implements public policy decisions, and those values include patriotism, national unity, sharing, devolution of power, the rule of law, and democracy and participation of the people. They must also encompass human dignity, equity, social justice, inclusiveness, equality, human rights, non-discrimination, and protection of the marginalized. Additionally, they include good governance, integrity, transparency, accountability, and sustainable development. We must ask at every stage the decisions that were taken by the first and the second respondents, do they meet the aspirations of Kenyans? Were those decisions that could bring about the free and fair election that they were expected to conduct? My Lords, this court being the arbiter of matters relating to the presidential election, or whenever we have difficulties, it was open to the IBC to come before this court and say, we are facing a challenge. You have ordered us to conduct an election within this time frame, but we have a challenge and we need help. The chairperson came to this court to argue numbers before the election. Why did he not come to seek clarification if there were challenges with regard to holding the election, an election that would meet constitutional muster under Article 81E? It is for, my Lord, again, it is for that reason that we actually say it was foreseeable with the reports that had been made by various organizations, national institutions. The first and the second respondent could not say, they could not foresee the difficulty or the challenge in holding an election that met all the principles under Article 81E, under Article 1 of the Constitution. It was not for them to decide whether some Kenyans get the right to universal suffrage and other Kenyans get an election that is free from violence, intimidation, improper influence. All these factors must be present at the same time for the same election. My lady? Again, my lord, it is not for the duty to ensure the environment or the electoral system is on the IEBC. That duty is placed squarely on them, not on any other body. So it is for them to make the determination as to whether they are able to comply with the principles provided under Article 81E of the Constitution. My lords, in the address that was made by the second respondent, the chairperson, one day to the 26th of October, 2017, the chairperson is still asking questions. In fact, he says, I have never heard of a nation where one day to the scheduled date of the election, the question on the lips of everyone is, will there be an election? He was alive to the facts and the environment within which he was operating. On the 25th of October, he says, I have watched and heard of terrible things that Kenyans have experienced in recent times in the hands of the police who are enjoined to protect them. Fellow Kenyans, excessive use of force by the police is not an illusion. It is the dark reality that some people have unfortunately had to experience in recent times. When the very people that we are expected to run to in times of trouble are the ones attacking us, then as a country, we are at our lowest. The innocent Kenyans who have signed up as staff of IEBC to serve their nation never for 1 minute expected that the job would be a risk to their lives. Only last week, the house of one of my staff was burnt down to ashes by people who, up till a few weeks ago, were friendly neighbors. When your decision to serve your country at home in a hallowed responsibility of midwifing democracy becomes as risky as going to war, then we are at our lowest. He's confirming what he already knew. And then the day after the election, he comes back and says, the houses of my staff were burnt, and proceeds to conduct an election within this environment. What then is the meaning of an election free from violence and intimidation? My lords, on 30th of October 2017, again, the chairperson confirms in a statement, it is in his own address, at page 195 of his affidavit, replying affidavit, he says, sadly, ladies and gentlemen, we must recognize that some of our members of staff lost their lives and property in the course of their duty in the 2 presidential elections. Regrettably, innocent children, men and women have lost their lives and property. Many have been injured or maimed, all in the midst of political competition. It is a submission that it does not matter who created the violence. It is sufficient that it was there and that it marred the election that was conducted on the 26th of October 2017. And for that reason, it cannot stand. It must be vitiated. Finally, my lords, I will take I will take 5 minutes to address the question of what we have termed dishonesty and duplicity by the first and the second respondents, which is borne out by their own documents. My lords, in the first respondent's replying affidavit, at paragraph 48 and 49, we have shown that the second respondent, the chairperson, admitted, owned the things that were said by Commissioner Rosalind Akombe, acknowledged them to be true, and then in his own affidavit to this court, he comes back and says that the views expressed in the said statement were the Commissioner's individual views and that they do not represent the views of the Commission. Yet he came and acknowledged them before Kenyans. He says, I further, at paragraph 51, he says that he decried the unfavorable environment owing to the political influence on the second respondent in the conduct of the fresh presidential elections, and then goes to say that he did not cast doubt on the second respondent's preparedness and ability to deliver a valid, fresh presidential election. Yet, in his own words, he expressed that doubt. So there is dishonesty where, when it suits him on one moment, he says one thing, and with another breath says something different. My Lord, in his own affidavit, again at paragraph 62 and 63, He says that in the preparation and conduct of the fresh presidential election, he admits the commission faced serious security challenges, including threats to its staff and infrastructure. Other commission processes, including trainings and deployment of critical election materials, were violently disrupted. He admits that. He further admits that there were security threats in 25 constituencies, which led to the postponement of the poll. Somewhere else, in his own affidavit, he says that those matters did not affect the poll or the election. That is two-facedness. That is dishonesty that cannot be the character of a leader.
Counsel, that being the case, which part of this evidence do you want to rely on, the dishonesty part or the earlier part? Because you can't advance both. You've got to choose whether you want to rely on the first one or where, according to you, there's a turncoat.
Malini, the character
May
then...
I just add something to that? You see, the court must depend on firm and stable evidence. And so there's that evidence which is sworn. It comes in the form of formal depositions. You have cited both types. And you seem to attach more weight to the general part, which is not sworn evidence, but you're not attaching significance to the sworn part. But the court must depend on the sworn part rather than the unsworn part.
My lords, actually, the sworn parts do confirm what we are saying. We're just saying that even within his own affidavit, he speaks with both sides of his mouth, because it is in his own affidavit that he's acknowledging.
Actually, that's my issue.
Yes, yes.
So what? So what? So what are you left with? What do you want us to take? Do you see where I'm going?
Soweto, if so he's dishonest, so he's double-faced. This petition is about the validity of a presidential election. Take us there. What does that mean to the issue before us? He's a chameleon. Yes, he may be. What about the petition before us? How does it affect the validity of the election? Take us there and save on the time.
My lord, I will answer the question and wind up on that so that my colleagues can deal. It affects the validity of the election in this way. By confirming himself that he could not hold a free and fair election, or by confirming himself that there was violence, the principle under Article 81E was not met. And where that principle is not met, we do not have a valid election, even without looking at any other principle. That is what we're saying. Thank you.